Hello everyone and welcome back to Courts This Week by LiveLaw. I'm Debojit Das. From a sitting High Court judge resigning in the middle of impeachment proceedings to the Supreme Court stepping in on Indian nationals allegedly forced into a foreign war and continuing constitutional debates on Sabarimala, of course. Last week has been anything but routine. So, let's get straight into it. We begin this week with a resignation that comes right in the middle of impeachment process. Justice Yashwant Verma of the Allahabad High Court has submitted his resignation to the President of India while an inquiry against him in the Parliament is still underway. In his resignation letter, Justice Verma has chosen to not disclose any reasons. He simply states that it was an honor to serve and that he does not wish to quote-unquote burden the President's office with an explanation. To remind you, this resignation comes amid proceedings initiated under the Judges Inquiry Act after 146 members of Parliament moved an impeachment motion against him. A three-member committee constituted by the Lok Sabha Speaker is currently examining the allegations. These allegations stem from a controversial incident in March 2025 when during a firefighting operation at his official residence in Delhi, a large amount of unaccounted cash was allegedly discovered in an outhouse. That incident had triggered both public outrage and an institutional action, following which an in-house inquiry was set up by the then Chief Justice of India, Sanjeev Khanna. Justice Verma was subsequently repatriated to the Allahabad High Court and his judicial work was withdrawn. The Supreme Court had even uploaded photos and videos from the incident, including visuals showing burning cash. Justice Verma had challenged this process, but the Supreme Court dismissed his plea, upholding both the inquiry and the recommendation for his removal. And now the resignation submitted in the middle of an ongoing parliamentary inquiry. Now a deeply troubling case has come up before the Supreme Court as 26 Indian nationals have apparently been trapped in Russia and forced to fight in the Ukraine war. The court was hearing a habeas corpus petition filed by their families and has now sought a response from the union government. Now, what's striking here is just not the allegations, but the consistent claim of inaction. Counsel for the petitioners told the court that there has been continuous and uninterrupted inaction by the authorities despite repeated pleas for help. According to the petition, these individuals had traveled to Russia on valid visas, as tourists, as students, and as people who were promised jobs. But once their passports were allegedly confiscated, their movement restricted, and they were coerced into joining military operations linked to Russian forces. Some of them had reportedly expressed fear, saying they were unable to leave the areas where they were deployed. And in several cases, families have now completely lost contact. There's no verified information about their safety, their condition, or even their whereabouts. What also comes out is that multiple authorities were approached. The Ministry of External Affairs, the Indian Embassy in Moscow, the Home Ministry, and even state governments. But according to the petition, there has been no effective assistance on the ground. The petition invokes Article 32, arguing that the Indian state has a continuing constitutional obligation to protect the life and liberty of its citizens, even outside the country, especially when they are unable to protect themselves. It also asks the center to disclose what steps have been actually taken so far, what protocols exist for these situations, and what diplomatic efforts are currently underway with Russia. And importantly, it seeks action against recruitment agents who allegedly sent these individuals abroad under false promises. Now, a politically charged case from the Telangana High Court, where Congress leader Pawan Khera has been granted interim anticipatory bail, but only for a week. The court has essentially given him a narrow window, 1 week, to approach the appropriate forum for regulatory anticipatory bail while protecting him from arrest in the meantime. Now, this case stems from an FIR filed by the Assam Chief Minister Himant Biswa Sharma's wife, Riniki Bhuya Sharma, over Khera's allegations that she holds multiple passports. The FIR invokes a wide range of serious offences, from cheating and forgery to defamation and intentional insult, registered at the Guwahati Crime Branch police station. What makes this more contentious is where the legal battle is playing out. Khera approached the Telangana High Court citing his residence in Hyderabad, but the Assam government strongly objected to this. Appearing for Assam police, the Advocate General argued that the plea itself is not maintainable in Hyderabad. He pointed out that Khera is a Delhi resident and questioned why he couldn't seek anticipatory bail in Assam itself. The state also went further to call Khera an established flight risk. According to the police, when they attempted to reach him, he allegedly evaded them and could continue moving cities to avoid investigation. On the other side, senior advocate Abhishek Manu Singhvi, appearing for Khera, pushed back strongly, arguing that the entire criminal case is politically motivated and driven by vendetta. The Telangana High Court has simply granted temporary protection, 1 week of anticipatory bail with conditions. Now to the West Bengal Special Intensive Revision, or SIR, of the electoral rolls, which is once again before the Supreme Court. And this time the concern is about timing and its direct impact on voting rights. The issue was mentioned before a bench led by Chief Justice of India Suryakant, where counsel pointed out that the Election Commission froze the electoral rolls on April 9th. The problem here is that a large number of appeals against deletions are still pending. And this isn't a marginal issue because reports suggest that nearly 27 lakh claims were were rejected during the SIR process. This is more than 3 times the population of Bhutan. Many of these individuals have already approached appellate tribunals, but with the rolls now frozen, there's a real risk that they could be excluded from the upcoming elections altogether. And that concern was directly flagged in the court, that despite having valid appeals, these individuals may simply be left out because of the cutoff. The Supreme Court has now taken note of this and said it will specifically consider the freezing issue on April 13th. So stay tuned to LiveLaw for that. But what strengthens the argument of the appellants is what has already emerged from this entire appellate process. In one of the recent cases, the appellate tribunal headed by former Calcutta High Court Chief Justice T.S. Shivagnanam found that names were deleted without proper application of mind and ordered their restoration. One notable instance is Congress candidate Mohtab Sheikh, whose name was reinstated after the tribunal observed that the Election Commission could not even provide reasons for his deletion. At the same time, the Supreme Court had earlier refused interim inclusion of such appellants while their cases are pending. So for now, they remain excluded unless their appeals are decided. This is a huge problem that even the court acknowledged. On one hand, there is a cutoff date tied to an election schedule, but on the other, there is a continuing constitutional right to be on the electoral roll and to vote in future elections. And as Justice Joy Malia Bagchi pointed out in court, that right is far more enduring. With the first phase of polling scheduled for April 23rd in the state of West Bengal, the court's decision on whether freezing of rolls can override pending appeals could have monumental consequences for the integrity of the electoral process itself. And now to the Sabarimala hearings in the Supreme Court, which were initiated before a 9-judge bench, but the court made one thing very clear at the outset itself. It is not directly revisiting the 2018 Sabarimala judgment. Instead, it is stepping back to examine a much larger constitutional question. How do you reconcile religious freedom under Articles 25 and 26 with fundamental rights like equality? And that shift has opened up a wide range of debates inside the courtroom. On one side, Solicitor General Tushar Mehta has made a strong pushback against the idea that religious practices should be tested through the lens of gender equality under Article 25. He argued that India cannot be viewed as a patriarchal society in the way Western frameworks often describe it. According to him, women have historically held positions of dignity and power, from the Constituent Assembly to the highest constitutional offices. His argument is that Articles 14 and 15 already guarantee equality and prohibit discrimination. So he says those principles should not be read into Article 25, which specifically protects religious freedom. But the bench has been asking uncomfortable questions too. Justice B.V. Nagratna raised the issue of menstrual taboos, questioning how a woman can be treated as untouchable for a few days every month and then not so afterward. The government's response has been that the Sabarimala restriction is not about menstruation at all, but about age-based customs that are specific to that temple and its traditions. From there, the hearings moved into a different question. Who gets to challenge a religious practice? Justice Nagratna pointed out that the original Sabarimala case came through a public interest litigation filed by people who were not even devotees. And she raised a concern. If there were a civil suit, it might not even survive for lack of cause of action. The Solicitor General supported this line of thinking, arguing that many PILs today are motivated and driven by hidden agendas rather than genuine public interest. He also took aim at concepts used in the 2018 judgment, like constitutional morality and transformative constitutionalism, not just questioning whether they should be used to reinterpret religious practices at all, but deprecated it by saying that he doesn't even fully understand the concept. And by day 3, the discussion had expanded beyond Sabarimala itself. The court began asking what happens if temples start restricting entry based on denominational lines. Senior advocate C.S. Vaidyanathan argued that Hinduism is not a monolithic religion. It consists of multiple traditions, each with its own customs, and those customs must be protected once you enter that religious space. But the bench flagged a deeper concern too. If every denomination starts saying only our groups can enter our temple, what does that do to the larger fabric of this religion? Justice Arvind Kumar captured that anxiety quite bluntly. He said, we will be dividing the society. At the same time, the government argued that not all religious restrictions are discriminatory, pointing to examples where men are excluded from certain temples or rituals to show that these practices don't always follow a simple male versus female logic. So the court is now grappling with questions that are far bigger than one temple, and LiveLaw will keep tracking them. Now to the Delhi High Court, where the CBI has strongly opposed applications filed by Arvind Kejriwal and other accused seeking the recusal of Justice Swarnakanta Sharma in the excise policy case. The core of the CBI's argument is that the alleged judicial bias cannot be inferred from a judge's past decisions or even their participation in public events. For context, this recusal application by Arvind Kejriwal was partly based on Justice Sharma's attendance at a seminar organized by the Akhil Bharatiya Adhivakta Parishad. But the CBI has pushed back sharply, calling such allegations unscrupulous and even suggested they border on contempt, as they tend to scandalize the authority of the court. It has also rejected the claim that the judge showed a predetermined mindset by granting an ex parte stay on adverse observations made by the trial court. According to the agency, staying consequences of an order that is itself under challenge is neither unusual nor legally suspect. And on the argument that the matter is being heard in undue haste, the CBI pointed out that 27 hearings have taken place in under 3 months, framing this as a part of an effort to fast-track MP and MLA cases. But perhaps the most significant part of the response is the broader principle the CBI is pressing. It warns that if such recusal arguments are accepted, it could open the door to forum shopping, where parties seek to avoid judges based on perceived unfavorable views from judges. It also reiterates that the composition of benches is the prerogative of the Chief Justice and cannot be altered at the request of litigants, which leaves the court with an important question. When does apprehension of bias become legitimate concern? Now to the Supreme Court, where the fallout from the NCERT textbook controversy is still unfolding. But this time, the academics at the center of it are pushing back. 3 academics, Professor Michelle Danino, Suparna Divakar and Alok Prasannakumar, who were earlier blacklisted by the court, have now appeared through their lawyers seeking a hearing. They filed personal affidavits, essentially asking the court to hear their side and to place the context of how that controversial chapter on judicial corruption in a Class 8 textbook was actually written. Now remember, on March 26th, the Supreme Court had not only banned them from participating in future academic projects of public institutions, but also made strong observations, suggesting that they either lacked proper understanding of the judiciary or had knowingly misinterpreted facts to create a negative impression among students. Today, that's exactly what their lawyers addressed. Senior advocate Gopal Shankar Narayan, appearing for Alok Prasannakumar, told the court that these observations have caused serious prejudice and that the authors are not acting casually but are credible academicians engaging with a new pedagogy under the new education policy. He pointed out that textbooks for other classes also discuss challenges faced by institutions like the legislature and the executive, so the judiciary wasn't being singled out in isolation. There was also a key clarification. The chapter was part of a collective process, not the decision of any one individual. The bench, led by Chief Justice Suryakant, briefly engaged by asking, "Are you defending your actions?" To which the response was that they are only placing context, not mounting a defense. For now, the court has agreed to list their applications after procedural defects are cleared. But now onto a list of important stories from across high courts that you should be aware of and shouldn't miss. The Kerala High Court last week stepped in to protect ongoing hormone therapy for transgender persons challenging the 2026 amendment. The court has made it clear that if hormone replacement therapy has already commenced, it must continue without any interference. It warned that abruptly stopping such treatment would lead to absurd results. This comes in the backdrop of a legal challenge to the amended definition of the transgender persons, which now excludes individuals who identify based solely on self-perceived gender without medical intervention. In court, it was pointed out that one of the petitioners has been undergoing therapy since 2019, but may not even be protected under the amended law. The petitioners also flagged a chilling effect on doctors, where they are hesitant to continue non-surgical interventions under the current framework. For now, the court has drawn a clear line. Ongoing medical treatment cannot be disrupted, even as the validity of the law itself remains under scrutiny. Now to the Allahabad High Court, which made an important observation on the relationship between the state and the press. The court was dealing with a case where Amar Ujala alleged that it was denied government advertisements after publishing a particular news report about a Gurudwara dispute. This was despite issuing a clarification. The High Court did not mince words here, as it said that dictatorial orders of this kind directly impinge on the autonomy of the press. What's also important here is the court's reasoning. It noted that if authorities have grievances against a publication, there are proper legal forums to address them. Cutting off government ads cannot become a backdoor method of control. The court also pointed out that the issue had already been addressed by the newspaper through a correction published later, making the government's response appear, at the very least, disproportionate. While the court stopped short of a strong intervention, it has asked the district magistrate to take a pragmatic view and reconsider the matter. But the larger concerns are not going away, it seems. When access to government advertisements becomes conditional, does it start to influence what gets reported and what doesn't? Now to the Bombay High Court, where stand-up comedian Kunal Kamra has raised serious concerns about how online content is being taken down in India, challenging the 2025 amendment to the IT rules, specifically Rule 3(1) Clause D. Along with the government's Sahyog portal, Kamra has argued that the current framework allows content to be removed without basic procedural safeguards. The core issue lies in how the system operates. According to the plea, the Sahyog portal enables thousands of government officers, even at the level of local police, to effectively direct takedowns of online content, often without notice, hearing, or a reasoned order. Kamra's argument is that this creates a parallel blocking mechanism, one that bypasses the safeguards built into Section 69A of the IT Act, which traditionally governs content blocking with some procedural checks in place. And that's where the free speech concern flares up. If content can be flagged and taken down through an executive-driven portal without transparency or remedy, it raises the question of who really controls what stays online. The petition essentially warns that this shifts the balance of power significantly away from judicial oversight and towards administrative discretion. This is an important case, especially when it comes to how online spaces are regulated, so stay tuned to LiveLaw for that. Now to the Kerala High Court, which has flagged serious concerns over the functioning of vigilance tribunals in the state. The court noted that despite crores of public money being spent, these tribunals are disposing barely 5 cases a year. Taking note of this stark mismatch between the resources and its output, the court has now directed a performance audit of these tribunals, and what seems to have weighed with the bench is not just the efficiency, but the larger questions of accountability in institutions meant to deal with corruption-related matters. If tribunals that are set up to ensure vigilance themselves barely function, it raises obvious concerns about whether the system is still serving the purpose at all. The court has now asked for a closer examination of how these bodies are operating and whether public funds are being justified by actual outcomes. Now back to the Delhi High Court, which has granted police protection to a live-in couple, even though both individuals are already married to other people. The court has now made a clear point about marital status and that it cannot be a ground to deny protection of life and personal liberty under Article 21. The couple had approached the court citing threats from the woman's husband on paper and family members. Despite the nature of the relationship, the court chose to not go into the legality and instead chose to focus on immediate concerns of safety. Justice Saurabh Banerjee held that as consenting adults, they are entitled to constitutional protection, regardless of whether they are married, unmarried, or in a live-in relationship. The court has now directed the police to ensure their safety and allow them to approach local authorities whenever required. The case stands out as the court's approach here was to separate moral questions from constitutional ones and places the right to life and liberty above social disapproval. And now for the last story, we come back to the Delhi High Court, where we have another important case concerning online free speech. As the Delhi High Court issued notice on a plea challenging the blocking of the 4 p.m. YouTube channel. The central government had blocked access to the channel citing grounds of national security and public order. But the petition raises serious concerns about how this action was carried out. It claims that the channel and several of its videos were taken down without prior notice, without disclosure of reasons, and without giving the creators a meaningful opportunity to respond. The High Court, hearing the matter, has now sought replies from the Union Government and YouTube and listed the case for further hearing. What sits at the center of this case is not just one channel, but the process that is being adopted in these cases, or the lack of it. When content is blocked on broad grounds like national security, without transparency or hearing, these concerns don't get addressed. And that's what the court will now have to examine. That brings this episode of Courts This Week to a close. Remember, for full reports, visit livelaw.in and keep following us on all our socials to stay updated with everything that is law.